obliged. I must get some, sir, always. You're the one speaking and you're out. So you think we are uneven? Start with the ladies, you were women in arbitration. They feel welcome. You distribute yourselves, can accommodate. You see gentlemen sit at the same table. So Mr. Kahimov, sorry, Philip, so it's okay. So highly of myself. How will you see it? The gentleman, the ladies. I don't want ladies, otherwise I'll be, yes, there you go. Okay, so we not on time, so as to stay calm. Give me 3 minutes. Commas, 3 minutes. Start the starting 3 minutes of starting. I started, but so we have started right the table with the ladies who correct me. Okay, someone will be in charge today, me, and then wrong. You come approach the bench. Come. In 3 minutes. Start. But for now, we have started. The next 3 minutes, if you are down trying to pack, tell you the valet guys, they are aware that ladies don't I also corrected that one, but to refer to gender was more were more than gentlemen. Now we want to start our symposium, given the time of our business. Ask you to arise. Not comfortable with standing, you can, given that it's very important, since we also honor this, and also the region. So I'll ask Kimbo, as you tell us, isn't it? Kimbo, and then we'll have our African anthem, national anthem of Uganda. Thank you very much. We'll have, before you sit, Chief Director Edith.
Okay. Let's pray. King of God, this beautiful day, we thank that here to Jalapik today with throughout this occasion, and we pray that whatever will come out with actual endeavor, occasions like the name of prayed and believe.
Thank you very much. Ladies and gentlemen, justices, our justices, not I again. You're all welcome. I'll protocol. May in the space of arbitration, dispute resolution, adjudication, and so this, after spreading into the, it will be women here for the very first time at symposium that we're having for women arbitration started the agenda of being, but also women mainly. So I'm to get to the podium, which is not, I feel, okay, so I'm distracted. Taking a podium to give a sermon, and normally churches and religious. So when you tell me to take a podium, I have to look for my scriptures, sermon for the day. We'll tackle as African women. When I say African women, I think the women, for one reason, to ladies somehow. I was starting it up chapter that way. I think the first match for women, and everybody, what's the man doing? So I think I'll be with the women, the ladies man. But our program is short, so we'll start the executive director of African women in Habit, Madam.
To get to know you. So thank you for coming. I hope you stay till the cocktail time so that we get to know each other and all that. I want to thank our partners. As an organization, we are new, but we have several partners. We have the Chartered Institute of Arbitrators, Uganda. Our new partner, Ellen Academy, Aisha is here, all the way from Kenya. We also have African Construction Law as our partners, the best in Nigeria. Yes. We have sponsors for the day. Sebalo Andule, S&L, DLA Piper. Thank you so much for sponsoring this event. We have Jevia Mukama and Company Advocates. I don't know if they are here, but thank you so much. We have Women Pro Bono Initiative as our silver sponsors for that day. A big clap, please. Ellen Academy, thank you, Aisha, for supporting us. We are privileged to have the MD of Uganda Clays here with us. Uganda Clays, kindly stand up. Thank you so much. Thank you, Mr. Ruben, for being here and for supporting us. We have LP Advocates. Mr. Gemara couldn't be here, but a hand clap for him for supporting us. Of course, Kenneth, we have Amber Advocates. Thank you so much, Kenneth, for supporting us. We have Jojoma Advocates. Thank you so much. And last but not least, we have the National Union for Lawyers. Thank you so much. So, what do we look for the outcome of this symposium? We're looking for recommendations out of this capacity building sessions, and we shall share the call to action at the end of this symposium. But with those few remarks, let's get deliberating and let's exchange ideas. Let it be a conversation, not just a presentation. Let's ask questions. And yeah, looking forward to engaging with all of you even during the cocktail hour. Thank you so much.
Thank you very much, Madam Edith, our Executive Director. I think we are now very keen, number one, taking opportunity. Since we have deliberately said that we'll sit in this room and ensure that if there are any appointments coming out of Africa, this room should have appointments of women arbitrators, women mediators, women adjudicators. I am a champion for women, I myself. I'll assure you, I was introduced to this very early, to champion for women. My mom stood for mayorship in this city, Kampala. We lost, but I did not give up. I have a daughter, and my name is Kenneth Akampurira. True, I'm a managing partner of Amber Advocates, and I have a bias on women. So if I ever become a judge and you're a woman, just be sure there's no harassment. Asking you to be audible enough. I know you'll have done your voice projection. So we'll quickly delve into our first panel, and I'll ask Madame Anne to arise. Just arise. I haven't told you to come. Just arise. Wave. Madame Anne, she's the managing partner at her firm, that is Namara Msinguzi and Company Advocates. She is an arbitrator, also a preferred adjudicator with the various spaces where she sits, especially in the build community. That means the engineers, quantity surveyors are her favorite. They always give her business. She's also the chairperson of our education and training committee at the Chartered Institute of Arbitrators, Uganda chapter. She's also one of our key players at the Construction Law Institute, still very instrumental in training. So when you have somebody who loves training, you definitely know that they will do a good job when they come to moderate. The questions are already with her. The answers should look from the panelists and the audience in terms of answers. Anne, I don't want to say much about you. I will ask you to arise. There's no national anthem to be sung. You will come up. Then I'll allow you to invite your panelists. Anne has over 15 years of practice as an advocate, and I can assure you she will not cross-examine anybody today.
Good afternoon. Thank you, Kenneth, for a very elaborate introduction. At one point, I wondered who he was talking about, whether he was talking about me, but yes, my name is Anne, as he said, and I'm honored to moderate panel 1. This is going to be a very exciting conversation. As Kenneth has said, we're here to talk, and it's not a lecture. So our first conversation will rotate around securing Africa as the most preferred seat. The law of the seat is a core component of arbitration. It's a bedrock, one of the bedrocks of an arbitration agreement. And in order to understand how to secure the seat, you have to understand what it is. So we're going to have our panelists, distinguished, highly seasoned panelists that are going to explore and help us understand what the seat is, help us understand the preferred seats, help us understand how we can properly position ourselves as Africa as the most preferred seat, and help us answer all your questions you have about Africa and the law of the seat. Allow me welcome them one by one. I'll start with the persons in the room. Miss Barbara Kiley. Miss Barbara, please come up. Miss Barbara is an advocate of the High Court of Kenya. She's a member of the Chartered, please come and have your seats, anywhere, feel free. She's an advocate of the High Court of Kenya. She's a member of the Chartered Institute of Arbitrators, and she's a mediator. Previously, she was a legal specialist at IDLO in Kenya, where she played a key role in reforms including the automation of the Kenyan judiciary's commercial and tax division, drafting the national ADR policy, and publishing the case digest on ADR. Currently, she is the country manager, Uganda, of the International Law Development Organization. Another hand clap for Barbara. We have our very own Michael Mafavi, the only gentleman on the panel. He's a friend of women. Please clap for him. He's a partner at S&L Advocates. Michael is a commercial dispute resolution lawyer, and his core practice areas in
rules. If the parties leave that question open and don't designate a seat in their arbitration agreement, then the institution will fix the seat of arbitration in any city around the world that is the most relevant to the particular dispute of the parties. This is how, for example, in a dispute opposing an African state in West Africa to a private company in Belgium, ICC has chosen to fix the seat of arbitration in Ouagadougou, Burkina Faso. So just to give you a clear example also of, from an institutional perspective of ICC, where that issue of seat venue might create sometimes confusion.
Thank you so much, Diamana. I think you've put that in perspective and you've thrown a spanner in these works. Allow me to throw this spanner deeper. You've spoken about ICC rules being the rules of procedure that govern an arbitration if the parties have chosen. And then we have the seat, and those could be two entirely different things. And then we have the law governing the arbitration, and we have the law governing the contract. Yes? I said I'm going to throw a deeper spanner in these works. Chizaram,
Yes.
help us understand the difference between the law governing the arbitration and the law governing the contract. Are they the same?
Now you are pushing it, Anne, but
Yes,
I
I
like
am.
it. So,
Yes.
no, and where I agree with you is that these are very important distinctions. And if anyone comes out of the room today having a clearer idea of how these different legal frameworks apply to an arbitration, then we would have done our job, I would say, on this panel. So, the law, let's start with the easiest. The law that is going to govern the dispute, the law that is going to be the law that the parties elected, not the dispute resolution process. I'm talking about the merits of the case, right? The law according to which the arbitral tribunal will decide whether or not a party introducing a claim, a principal claim or counterclaim, is warranted in its claim, is the law that the parties would have chosen in their contract as the law governing the contract in general, right? So you would often have a clause about the applicable law that says this contract is to be interpreted under the laws of Uganda or under the laws of Kenya, right? So that is the law applicable to the merits of your dispute. Now that law might not be the same, or it might be the same as the law that will apply to the procedural issues in your case of the arbitration. The law that will apply, that will govern the procedure between the parties, is often not provided for in parties' agreements. It's quite rare to come across that. Sometimes we have it. So that clause would say something along the lines of the arbitration will be governed by the laws of Uganda, right? So then we know that this is the law that the parties elected to apply to the dispute resolution process, okay? But most of the time, what the parties do is that they elect if they elect an institutional arbitration, the institution. So under ICC rules, that would be any dispute arising out of this contract will be resolved. That's the model clause of ICC. Any disputes arising out of this agreement will be decided by arbitration under ICC rules. That does not give an indication of which legal system is going to apply to procedural issues in this dispute resolution process, but it does give an indication of material rules that the institution have in their booklet, ICC rules, that will indeed govern the constitution of the tribunal, any issues with respect to financial aspect of your dispute, any issues with respect to the timeline of the dispute resolution process. Now, of course, there is a legal framework that applies to the arbitration beyond the arbitration rules that have been selected by the parties, because the arbitration rules do not resolve all issues. I can give you an example. You have a number of laws of arbitration. Let's say in the OHADA region in Africa, the OHADA Uniform Act on Arbitration has a timeline that is projected for the dispute resolution process to take place. That is 6 months, okay? If you pick an arbitration, the rules of an arbitration center that does not have any provision on the timeline within which the arbitration award has to be rendered, and the parties through conflict of law rules, either the parties have provided for the law applicable to the dispute resolution process, so governing the arbitration process, or through conflict of law rules mechanism, the tribunal elects the law of one of the OHADA countries as applicable. So that in our case, for example, where the seat of arbitration was in Ouagadougou, Burkina Faso, then the laws of Ouagadougou and the arbitration law of Ouagadougou, Burkina Faso would govern the arbitral process. Then these are the laws that will determine the timeline afforded to the arbitral tribunal for rendering its award. So just to simplify, again, choosing the law applicable to a contract does not amount to choosing the law governing the procedural aspect of your dispute resolution mechanism. You can provide for it specifically in your contract. Whenever you have not, then it will fall on the arbitral tribunal to select the law that applies to the procedural that governs the procedural aspect of your dispute resolution mechanism, and it will do so using conflict of law rules, depending, of course, on a number of aspects. In particular, the nationality of parties would come into account, the place where the execution of the contract is happening, and indeed one of the factors in those conflict of law rules is the seat of arbitration chosen by the parties. But it's some of the seat governing the procedural rules. Many arbitration lawyers even themselves make that shortcut. It's not systematic. I will stop there.
Thank you so much. I hope we are not lost. Are we still together? Thank you, Diamana Chizaram. I would like you to take it from there. Are you with us, Chizaram?
Can you hear me?
Yes, please. So,
great.
In the case of one of the recently decided cases of SulAmerican versus Enesa and others, the Court of Appeal in England agreed with Diamana that the law governing the contract is different from the law governing the arbitration agreement. At times, they could be the same, but you cannot easily impute that they are the same. Very briefly, help us understand the reason why court decided that way, why court agreed with Diamana in that aspect.
Okay, thank you very much. I'm just going to echo the appreciation of Diamana and say thank you for inviting me to speak on such a relevant issue. Good morning to the audience. It's a pleasure to be here. I would have preferred to be physically present, but due to circumstances beyond my control, I have to join virtually. But in any event, I think it's going to be an engaging session. I'm already enjoying this session and listening to what Diamana has to say. Now, regarding the question you just asked about the decision of the English court in the SulAmerica case, I would say that the SulAmerica case kind of clarified a very dicey issue in international arbitration, which is what law will govern the arbitration agreement. Now, it's a very tricky question because there are various laws that come into play in a dispute. And as Diamana had mentioned, there's a law that governs the contract, which is the merits of the dispute, the interpretation of the contract, the validity of the contract, the termination of the contract. So, for instance, I'll just to make it give a practical example. I am a property developer, and I want to build an apartment complex in Kampala, Uganda, and I get a building contractor to develop or build that apartment complex. Now, for the law governing this contract with the building contractor, I might choose to go with Ugandan law to govern the contract because, well, the contract is going to be performed in Uganda, so it's just convenient to have Uganda as the law governing the contract. However, the contract might have an arbitration clause, which says that every dispute arising from this contract will be submitted to arbitration, and the seat will be England or London. Typically, it's cities parties choose. Now, when I have chosen London as the seat of arbitration, typically, London, the laws of England will govern the arbitration proceedings. Why so? That's because if you have a need to maybe go to the courts in England to ask for interim measures, or if you have a need to request for interim measures of protection, you would typically go to the courts where the arbitration is seated. Those courts are best suited to provide you with the interim protection you need. Likewise, if you need any other form of support in the arbitration process, because the arbitration is seated in that particular jurisdiction, the national courts of that particular jurisdiction are best suited to assist you in supporting your arbitration process. This is why the law governing the arbitration procedure typically is the law governing, typically is the seat of arbitration. So the country where your arbitration is seated will determine the law governing the arbitration procedure itself. Now, that's different from the law governing the arbitration agreement. And that's where the case of SulAmerica comes in. Because what I find in practice is that parties we'll select, say, in my case study, Ugandan law as the law governing the contract. And then parties will say, even though, as the Amana said, they may not say, well, the law of England will govern, will be the governing law of the arbitration procedure. What you would find is that they will say, London is the seat of arbitration. So implicitly, the law of England will govern any arbitration procedure. But what you don't find in a contract is an express, or what is not very common, rather, is an express inclusion of what law will govern the arbitration agreement. And that's why it has been an issue, because it's not a very common circumstance. And we have two schools of thought in this area. The jurisprudence is divided. And when I say jurisprudence, mostly English law jurisprudence, because I mean, English law is the most advanced in terms of building the legal jurisprudence for arbitration. Now, the jurisprudence is divided in that some father believes that should also be the law governing the arbitration agreement. Another school of thought believes that the law of the seat or the law governing the arbitration procedure should also be the law governing the arbitration agreement. Now, I will explain the reason for the first school of thought. The first school of thought believe that the law governing the contract should also apply to the agreement itself, not the procedure, not the arbitration procedure, because, I mean, that's a totally different issue, but should apply to the arbitration agreement because the agreement typically falls as a clause under the contract. So even if parties have not expressly stated that Ugandan law is the law governing the arbitration agreement, because it falls as a clause under the contract, and the contract itself has a general governing law, which is the law of Uganda, it then means implicitly that the governing law of the arbitration agreement, forming part of the contract, will be the law of Uganda. I mean, that makes sense. But the problem with that school of thought is that there's a general principle of separability, right, of the arbitration agreement from the other parts of the contract. This means that it is possible that a contract will be invalid, but that invalidity doesn't affect the arbitration agreement. So the arbitration agreement can survive the contract. So it is actually possible for the arbitration agreement, for the law governing the arbitration agreement to be different from the law governing the contract. And this is where the other school of thought comes in. They believe that, no, it cannot be the law of the contract governing the arbitration agreement. It has to be the law of the seat, right? So where the arbitration agreement is seated in London and the contract is governed by Ugandan law, then it automatically implies that the arbitration agreement will be governed by English law because they use the most closely connected principle, because English law is the most closely connected jurisdictional law to the arbitration agreement. Why so? The reason behind this is that, unlike every other clause in the contract that governs the substance of the dispute, the arbitration agreement is only a procedural aspect of the contract. So it is merely an undertaking by parties that any dispute will be resolved by arbitration. And you have the law of the seat of arbitration, which basically provides support for the entire arbitration process, which the arbitration agreement is based. Therefore, it is the seat of arbitration, or the law of the seat of arbitration, that has the closest connection with the arbitration agreement and not the law of the contract. So that school of thought believes that it is the seat of arbitration that should be the law governing the arbitration agreement, where parties have not expressly stated that law governing the arbitration agreement. And now that brings me back to the Sul America case, because what the Sul America case does is to clarify. So what is it, the law of the seat? Is it the law of the contract? What should govern the arbitration agreement? And the English court what the English court did basically was to set out a three-pronged rule, and which Diamana had actually referred to it during her presentation. It set out a three-pronged rule to determine what exactly would be, what is the test for determining the law governing arbitration agreement. And the English court said the first step to take is to determine if there is an express provision in the contract to govern the law governing, talking about the law governing the arbitration agreement. And of course, we've mentioned that it is not typical to have such express provisions. The next step is to determine if there's an implied agreement between the parties as to what law will govern the arbitration agreement. So if we cannot find an express term, then we should be able to imply the term from the contract. And in navigating this issue of implicit term, the English court stated that where the contract has an express governing law, I mean, it has a clause that, or where the contract states out the law governing the merits or the law governing the contract, then the arbitration agreement will be the same. The law governing the arbitration agreement, rather, will be the same as the law governing the contract. And the English court pretty much applied the reasoning of the first school of thought to say that businessmen typically will want to have the same law governing their the arbitration agreement and the arbitration and the main dispute. It is not likely that businessmen will want to have separate laws governing for different parts of their contracts. So it is generally, it is implied that they want the same laws. So if they have chosen Ugandan law, for instance, to govern the contract, then it will be implied that they have also chosen Ugandan law to govern the arbitration agreement, which forms part of the contract. However, the court makes an exception. The court then says, except there is any circumstance or any fact that indicates otherwise, that indicates a contrary intention by parties. So the issue of implied terms of the contract, or the issue that the law governing the contract would become the law, will also be the law governing the arbitration agreement, is only a rebuttable presumption, right? That presumption can be rebutted if there is any other term in the contract that gives a contrary intention. And that could be where the contract has expressly stated a seat of arbitration. So you have a contract that says the law governing, let's use the building contract now. The law governing this contract is Ugandan law. However, parties have decided to sit this arbitration in London. The court in Sul America says that by expressly determining the seats, then it presents a contrary intention of parties. Now, the court then goes further to say that where the implicit terms of the contract cannot be definitely determined, then parties will then go to the next step, which is the law, the law which is most closely connected with the arbitration agreement.
Thank you.
And in that point, I'm sorry, I'm just going to wrap up shortly. And in that point, the court basically said that where parties have chosen a seat of arbitration, going back to the initial reportable presumption point, when parties have chosen a seat of arbitration, then that seat will be presumed as the jurisdiction most closely connected with the arbitration agreement. And in that case, that will be the law governing the arbitration agreement. So to summarize, it's a quite Sul America case. It's a quite complex case. It's not that straightforward. The court does not say, to answer your question precisely, that the law governing the contract will always be the law governing the arbitration agreement. What the court does say from all its analysis, is that it is possible for the law governing the contract to also be the law governing the arbitration agreement, where that is implied, right? However, it will be different where parties have basically selected a seat in the arbitration in their contract. Where parties have selected a seat, then in the absence of an express choice of law governing the arbitration agreement, it will technically be the seat of arbitration that will govern the arbitration agreement. So that is pretty much what the Sul America case says. And to just draw that distinction and apply that three-pronged test to determine what law will actually govern the arbitration agreement. Thank you.
Thank you. Thank you very much, Chizara. My take home is that we must be very precise when drafting our arbitration agreements in order to avoid such ambiguity, because as Chizara has said, the schools of thought are two. One, if your agreement is quiet as to what law governs the arbitration agreement, the pendulum can swing either way. The court can decide to adopt the law of the contract as the law governing the arbitration agreement, or it can decide to adopt the law of the seat as the law governing the arbitration agreement. So in order to avoid this confusion, we need to be extremely precise when we're drafting, that comes out clearly. But in cases where we are not, Michael, I would very quickly help us understand locally, how have courts determined the interplay between the arbitration agreement, the law of the arbitration agreement, the law of the seat, the venue, and the law of the contract in disputes before it? How have they determined the interplay?
Okay, thank you very much, Anne, and of course I will echo what my colleagues have said. Thank you to the organizers for organizing this event. Kenneth, you're not alone. I think I'll take it that I'm also a ladies' man. And I thank you for inviting me. This morning when I was leaving, I told my 3-year-old daughter that I was going to be in great company this afternoon. So,
please, a hand clap for Michael, the ladies' man.
Yeah, so, Anne, I think Chizaram and Dianama have drilled down and sort of broken down the issue. It's a very controversial issue, and many times tribunals get it wrong. Sometimes we counsel get it wrong, and sometimes the judges get it wrong. And the question that you're posing to me is with regard to the courts and how the courts deal with this. It's really a question of the law applicable. In a typical international arbitration proceeding, you may have about 2 or 3 laws, and I dare say sometimes even 4, which are applicable to the different aspects of the arbitration. I think Chizaram and Dianama have covered it extensively. So the courts always approach that situation carefully. In one instance, in one single proceeding, you may have a different law that applies to the contract, which is a governing law. And that's the most common clause that we find in contracts. The governing law of the contract shall be X. And then you have the law applicable to the arbitration agreement. And then you have the law of the seat of arbitration, which is what they call the lex arbitri, of a particular connection with the arbitration. And I dare say the 4th law may be the law of the forum, where the issue of what is the law applicable has arisen. It happens sometimes in very complex matters. So the manner in which the courts have always approached this, it starts with the agreement and party autonomy. The courts will always draw reference to the party's choice of what the law applicable should be. That's the first approach. And we saw it in a number of cases. But maybe let me first of all talk about the issue of venue, which Dianama touched upon. The issue of venue has also recently become controversial. And the court was faced with a situation where parties had agreed in their agreement and made reference to the venue of arbitration being London. And that case was recent in 2020 in an English decision called Process and Industrial Development versus the Republic of Nigeria. It was a live issue. So the issue of venue, whilst the courts have tried to provide clarity, appears to remain controversial, but the controversy arises from the drafters of these agreements. In that case, the parties had said the venue of the arbitration shall be London. They did not distinguish the venue from the seat of arbitration. And the English court, which was the High Court of England, determined that the reference to the venue would be the seat of arbitration. And they gave various reasons. One of the reasons was that it was inconceivable for the parties to have agreed to the venue being the location of the hearings or the tribunal's meetings to deliberate issues in the arbitration. It would be inconvenient to the parties. And therefore, the English court took the view that the reference to the venue in the agreement can only be construed as the seat of arbitration. So even while we discuss the question of venue, which was your starting point, Anne, and I think which Dianama addressed, it is still quite a controversial area in distinguishing the two. Now, what's the court's approach in respect to the different laws which interplay in a typical international arbitration? I think the two colleagues who spoke earlier have sort of covered the court's approach, but I think maybe just to clarify, because away from Sul America, which I think for a long time was a leading case on what the law applicable to the arbitration agreement should be, recently, I think in 2019, the English Supreme Court in Enka versus Chubb has determined a similar issue and has, I recall reading the judgment of the Court of Appeal of England before the matter went to the Supreme Court, where the Lord Popperwell, I think it's called Popperwell, said that time has come to put to rest all controversies regarding the confusion as between the law applicable to the agreement, the governing law, the law applicable to the arbitration agreement, and then the law of the seat of arbitration. So the court in doing so observed that in the case where the contract specifically provides for the governing law of the contract, but does not provide for the law governing the arbitration agreement, then the default position is always that the governing law of the contract will be the law applicable to the arbitration agreement. Now, the court also went ahead to say that where the parties have not agreed a governing law in their contract, then generally speaking, it is accepted that the law applicable to the arbitration agreement will be the law of the seat of arbitration. Those are two critical points that the Supreme Court of England has now come to clarify the decision of Sul America. And I think they reviewed various decisions. So that appears to be, one would be tempted to say, a settled question on default positions. Yes, so the second distinction was, which the court said, that where the parties have not agreed a governing law of the contract, then the default position will be the law of the seat of arbitration in determining what the arbitration agreement is. So we have that progress and development in the law now, and we've recently seen it even in jurisdictions in Africa which have accepted that decision. Recently there was a case before the commercial court here in Uganda where the court took the same view in terms of determining what the law applicable to the arbitration agreement is, and referred to the English decisions so far determined, and determined also that in determining whether a particular law applies to an arbitration agreement, the court starts with party autonomy. If there was an express choice of law, then the parties will always be held to their bargain. Now, how do the courts arrive at a particular law which is applicable in respect of a particular arbitration? The courts, I think, as Shizaram said, look at implied terms, the principle of implied terms, where there's no express choice of law. Where that choice is also absent, the court will always look at the closest connection. And maybe just to add to my voice to what the two able ladies have said, we need to ask ourselves, what does the closest connection mean? It sounds like an amorphous term, but essentially what the court looks at is, what are the attributes of the arbitration that connect it to a particular jurisdiction? For example, the court may pose questions like, where is the evidence likely to be located? Where are the witnesses who may be potential witnesses in this arbitration? Where are they likely to be found? The court may also look at the agreement of the parties to see what was the choice of law governing the contract, to discern an intention of the parties as to which law applies to an arbitration agreement. So without creating a lot of confusion, I think those are the approaches that the courts apply in dealing with this whole interplay between the different laws that apply to a specific arbitration proceeding. I think I'll stop there, Anne, for now.
Thank you very much, Michael. I think you've shed more light, and you've spoken about party autonomy, and courts consider party autonomy. Yes, it's a fundamental principle of arbitration. As parties exercise their autonomy, what do they need to look out for in choice of seat? Why is it so critical to pay a lot of attention to the choice of seat in an arbitration agreement?
The choice of seat is important because I think, as the earlier speakers said, when you agree a choice of a particular seat, you effectively import into the arbitration a particular procedural law of a jurisdiction that you agree to govern the procedure of the arbitration. That's the first principle. So the choice of seat is important because when parties are contracting and you choose a particular seat, you may end up importing a foreign procedural law. And if you don't understand the implications or understand the sort of certainty that that law gives in terms of jurisprudence in that jurisdiction, then you might end up stuck at a certain point. So, for example, common law parties may contract and say the seat of arbitration is a civil law country, and there's always the clash between common law and civil law jurisdiction. Important because you have imported, when you agree, you have imported a particular law into your arbitration. Now, the choice of seat is also important in terms of looking forward. When parties are contracting in a particular agreement, dispute resolution lawyers must always be foresighted and look to the end in the event a dispute arises. How will an award in a particular arbitration be enforced? And which legal regime would apply to enforcement? Of course, if it's a foreign award, normally we see that the New York Convention applies in terms of recognition and enforcement of the awards. Now, the importance of the choice of seat is that the choice of seat is a recognized principle under the New York Convention. And I think Article 5, which governs recognition and enforcement, specifically regulates the fact that the court in which enforcement is sought must be satisfied that the award which is before it is a valid award and has not been annulled at the seat of arbitration, right? The New York Convention also expounds on the question of the choice of seat by recognizing under Article 5 still that the court must be satisfied that the parties exercise their autonomy in selecting the seat. If one of the parties was deprived of that choice and the arbitration proceeded, the award may be contrary to public policy in a particular jurisdiction, and therefore recognition and enforcement may be refused. I think the choice of seat is also important because it is that law which provides the basic standard of evaluation of the validity of an award when it comes to actions for setting aside. Actions for setting aside are often at the seat of arbitration in a typical international arbitration proceeding. So therefore, parties contracting and making choices of the seat have to be mindful that the choice of law of the seat which they import into the arbitration will be the law that governs actions for annulling arbitrations. So those are the three main areas that I would say parties need to take care when they are making choices for their seats.
Thank you, Michael. Michael, you've spoken about three critical points that are considered in choosing a seat. I would like to go to the other side of the prism and introduce a fourth: geopolitical considerations. Barbara is smiling. She's eager to answer that question. Do geopolitical considerations influence the selection of seat of arbitration? And as a follow-up question, do you think the legal environment in Africa is adequate?
Thank you, Anne, and allow me to just echo the comments of the previous speakers in thanking the organizers for inviting us to this conference. And I'm sure you're all wondering why, as lawyers or as practitioners, geopolitical considerations should be important to you. One of the key things that I have always noted, especially when it comes to drafting, is that you must always keep in mind the enforcement of any outcome of any dispute resolution process. So when you're crafting the ADR clause, keep in mind what steps you need to take into consideration or to take into account when it comes to enforcing any outcome that arises out of it. And geopolitical considerations are one of them. And Michael said it very well when he mentioned public policy, which is where geopolitical considerations come in, because most of the times we do not take into account what public policy means in the jurisdiction that we want enforcement to be undertaken. Case in point, you could be making a transaction with a company that perhaps has chosen the seat to be somewhere in the Middle East, and maybe the governing law of the contract and also the law of the lex arbitrii would have inferences of Sharia law, yet the contract has got significant questions of interest. Now, when it comes to enforcement, would that be enforced? So these are the kinds of issues that you need to think about. But not just that, there are also political considerations. There are entities, or rather countries, where we know when we want to get into an agreement, you have to think about what is the political environment in this particular country. I'll give you a case in point, the Sudapet versus the Republic of South Sudan dispute. That arose out of geopolitical issues. It was not mainly out of how the contract was going to be implemented, but simply because of the tensions between South Sudan and Sudan played out. And the effect of that is that you now have an ICSID award that is now holding the Republic of South Sudan liable for payment to Sudapest of some significant portion. Yeah? And then you have the country itself not being able to pay because of the different decisions that the government, the current government, has taken, including the latest, which is now to suspend political elections for a further 2 years. These are issues that normally we don't take in mind when you're drafting contracts, but are very important. And one thing that we've noted, especially when you have to think about public policy, because when it comes to enforcement of such an award, where are you going to enforce? For example, where would Sudan go to enforce the South Sudan award that ICSID has rendered? Where would they take South Sudan to? Would it be in international forums? Would it be trying to get their assets that are international? Are there any assets that South Sudan has? Probably they do. But there are questions that you really need to start thinking about when you're making any drafting, when you're drafting the clause for arbitration and looking at how that particular contract is going to be implemented, and later on any outcome out of it is going to arise. Now, you had initially when Diamana started, she mentioned about how a seat, I mean, the venue of the particular arbitration had chosen Syria, and then the war broke out and they had to go to Beirut. Imagine if that's still a dispute that's ongoing right now. It would mean that if they are not locals of Lebanon, they would have to change where the seat is if there's someone who's an international, because now you cannot access Lebanon because of the current issues that are going on there. So these are impacts that actually affect the implementation of a contract, that make it necessary for we as drafters, we as lawyers, we as negotiators to always keep in mind the changing circumstances politically to be able to choose seats that are geopolitically neutral. And that means that in Africa, we really have to sit down and think which of our African seats would be considered to be geopolitically neutral. I leave that to you. I see many of you smiling. I leave that to you because I know most of you start looking at the political considerations that we all have going on. But you also need to think about something else. What about the independence of the judiciary where you want to carry out enforcement proceedings? How independent are they? How detached are they from the processes that are trying to align themselves to different political considerations? One other thing that will be important for you to look at is whether a country is a capital in nature or socialist in nature, because that tends to tell you how the interpretation of any proceedings that will be brought to the court is likely to pan out. And these are important considerations. So those would be the kind of ideas that I would always keep in mind when it comes to drafting of arbitration clauses and the dispute management plan. Now, the second element of your question you asked was, what do we need to, how do we make the legal environment adequate for promotion of arbitration? For me, what I've seen happening, and this is going on Africa-wide, and what I believe is going to bring African seats to the international arena, is the changes that are currently going on in the different legal frameworks for arbitration. So you will find, like, for example, if you look at Tanzania, they recently had an amended act on arbitration. If you look at South Africa, they have a different regime for the arbitration processes. This kind of constant review of your legal framework that then allows the recognition and enforcement of arbitration outcomes helps. Also, the attitude that the judiciaries have across Africa is very important. Recently, the Chief Justice of Uganda held an Africa Chief Justices Forum on ADR, increasingly showing the acceptance of judiciaries that this is a dispute resolution mechanism that is very important and is critical in promoting sustainable development of African countries, and also promoting African countries as seats, or rather African legal frameworks as seats for arbitration because of the investment element. Because let's not kid ourselves, dispute resolution is an economy in itself. You have lawyers flying in, you have advocates being engaged, counsels being paid, experts. All these are economies that we need to think about. These are resources that we can attract to our countries. And when we're thinking about improving our economy status, dispute resolution is one of the key investment areas that we should be looking at as a means of attracting investment. So when you look at the ability of any judiciary to accept the outcomes of the parties by promoting party autonomy, respecting what the parties have put into their contracts. It's very important. So when you find that you have a judiciary that interferes with party autonomy, excuse me, my ladies, but this is the position in some of the African countries. When you find that you have a judiciary that interferes with party autonomy without using the properly laid out modalities, either this particular jurisdiction could have adopted the ancestral model law and refined it for their own application, then these are the critical factors that we will be looking at as things that would be promoting African seats. And it's important also to consider the question of reciprocity. I know many of the African countries are signatories and have ratified the New York law, the New York Convention law, and it's important for us to consider the question of reciprocity. Most of the times when we are ratifying conventions, the most unfortunate thing is that sometimes we do not read the details. We don't read all the details of the convention to find out how do we protect the different, I would say, the different economies that we have within Africa, or the different sovereign state powers that we have within Africa. Most of the time, and in considering how to promote African seats, it will be very important for us to review the conventions that we have all signed on to. So if it is a New York Convention, if it is different, for example, the bilateral investment agreements that we all have, it's very necessary for us to go back, review, and see how best we can improve the legal framework to ensure that not only are we enhancing the capacity of the lawyers within, which is also another issue that we need to look at. But we're also looking at how do we promote, and no digs to Diamana, I know she's here, how do we promote the local or the regional arbitration centers that are within Africa, because that is important. I mean, we can only improve an Africa if we start looking at it from an African perspective. Most of the time we want to put in our contracts that we want to go to London. Why? What does London have that Kampala does not have, for example? What does London have that Kigali does not have? They have the hearing facilities. You can get the hearing facilities also in Nairobi. You can get same level of expertise in Africa. So it is important that we start thinking of, when we're thinking of how to improve the legal environment, the capacity. Michael rightly said when we were having a chat when I came in, how they do the secondment processes within the legal framework, legal agreements for the law firms that they have. Maybe it's about time as Africa we think about how we can exchange expertise between the different African countries, because we have built the capacity. It's not like we don't have it. So for me, I would say the legal framework, we need to review it. We need to keep pushing for alternative dispute resolution policies that recognize and inculcate in us, including changing our education models to bring up dispute resolution that is alternative to the judiciary from the beginning of our curriculums as a young person. So that when we grow up, we are not a litigious public society, but rather we are a society that looks at how do we amicably settle all our matters. It could be through arbitration, it could be through mediation, whichever way we choose to do that. And the other thing would be to ensure that most of the countries that now have fly-in, fly-out regulations, most of our African countries don't do that. For example, it can be very hard to practice in Uganda for a Kenyan because you must be qualified in the bar. Yet, I think for Ugandans, you can practice in Zambia. Is it Zambia or Zimbabwe? Zimbabwe, yeah? By virtue of being qualified in Uganda, you can practice in Zambia. Imagine if that was open to other African countries. We are mostly common law jurisdictions. Why is it so difficult for me, who has qualified in Kenya, using the laws that are similar to Uganda, not be able to practice in Uganda? Because I must come here, I must go to LDC, I must qualify at LDC, and I think I must also do my clerkship And now we all know the challenges that are going on in being admitted to LDC. But so when we're trying to see the different ways in which we can promote African seats, I think sometimes we are not looking at the available mechanisms that are just available for us to draw on. Lastly, I'll just speak about visas. If you're going to promote African seats, we must look at movement. How easy is it for you to move within the African continent? I will need a visa to go to, no, nowadays I don't need one to South Africa. I need a visa to go to Nigeria. I need a visa to go to Egypt. I need a visa to go to Wales. Very many other African countries. In Uganda, I can come in and out because we are East African, we have facilitated that. But these are the kinds of questions that actually we need to address to be able to think of how we can promote African seats, because mobility is one of the ways that we can improve trade. I mean, we already have the African Continental Free Trade Agreement. It has the investment protocol. It has the services protocol. These are things that we know will bring disputes to us, but we are not thinking about how we can leverage on the fact that we are one Africa and be able to move around and understand the different legal jurisprudence through secondment in the different legal institutions that have been established and registered in the different categories, so that we build our capacity and we continue engaging as Africa.
Thank you so much, Barbara. Those are very wonderful parting shots. Sorry, our time is fast spent. Thank you so much. Michael, in 2 minutes, what would you recommend should be done to secure Africa, in addition to what Barbara has said, as you also give us your parting shots in 2 minutes?
Yeah, thank you. And I think there is a whole conversation of Africanization, of arbitration. It's a whole debate that is going on. And I think that initiatives like this one are a platform for us to talk about it. Nobody is going to lead the conversation but ourselves. And I think that one way to do it from an institutional perspective is to encourage collaboration. There is, of course, the whole discussion about proliferation of many Africa institutions. You know, some people argue that there are so many institutions which are, in fact, competing against each other, rather than complementing each other. And I think that we need to leverage from established institutions like the ICC to collaborate and grow the younger institutions in Africa. That's one way to position ourselves, as a preferred, seat. Now, my final point is on the opportunity that comes with the Africa Continental Free Trade Area. It's a treaty that has been signed off, I think, and accepted by most Africa countries. But we need to dig a little bit more and understand what opportunities it brings, because it has a specific protocol on dispute resolution by arbitration. And that of itself, of course, positions Africa as an attractive seat from that perspective. So those would be my thoughts.
Thank you. Thank you so much, Michael. We've had a collaboration, not competition. Chizaram, in 1 minute. Are you still online? Chizaram, this time I'm giving you 1 minute. I'm going to time you. Yes.
Okay, so
just before you answer, Nigeria, Nairobi, South Africa, according to the recent report of ICC, have emerged as the poster children in Africa for the most preferred seat of arbitration. What leaf can the rest of Africa borrow as we seek to make ourselves a preferred arbitration seat? And your closing remarks.
Okay, thank you. Nigeria, South Africa, Sierra Leone, and I think that was Kenya.
Kenya.
One thing that they all have in common is that over the past 4 years, they have made efforts to demonstrate that they are eager to develop arbitration in Africa. They have been proactive in doing that. And that is one thing that I believe that other African countries can learn from. Taking, for instance, Nigeria, we all know about the recent Arbitration and Mediation Act. We also know that the AFSA has recently joined the International Federation of Commercial Arbitration Institutions. We know that Kigali Nairobi has one of the top seats of arbitration, one of the top arbitration institutions in Africa. And we also know that Sierra Leone recently ratified the New York Convention sometime in 2020 and currently has a bill at its parliament for improving its arbitration laws. So that's what I would just say. I think one leaf that other African countries can borrow from them is just to continue to push for an enabling environment that makes Africa look like an attractive seat, just like all these countries have done. And just as a closing remark, I want to say that I think that we are already trying, and I have to commend the effort that a lot of African jurisdictions are putting in, and not just African jurisdictions, but also general initiatives in the continent. We know of the African Arbitration Academy that is currently doing a lot of capacity building. We also know of ICC that recently organized the training for arbitration practitioners in Africa. So we see that there's a lot of efforts being put in. Rome was not built in a day. Most of the top seats of arbitration, London, Paris, Geneva, Singapore, they built their reputation over time. And I think that it's important that we give African jurisdictions some grace and allow us to grow at our own pace. We are trying, more can be done, but I also think that we are doing really good, and that it all depends on just being consistent in the efforts that we are putting in. And I believe that we will begin to see the benefits of doing that. So that's my final remarks. Thank you very much.
Thank you so much.
I hope I didn't extend my time.
No, it's okay. And finally, Diamana.
Yes, thank you. Yes, I'm here.
Diamana, just before you give your closing remarks, according to the ICC Dispute Resolution Statistics Report, as Tizaram mentioned, the leading seats were United Kingdom, Geneva, and France. What leaf can Africa borrow? I know Barbara has said that we should strongly and firmly promote Africa, but those are the leading statistics in the world. So as ICC representative, African director, what leaf can Africa borrow to make it a most preferred seat, as you give us your final shots?
Thank you very much. And I think one common element between those preferred seats that you have mentioned, Paris, London, Geneva, and you can add a few to that, even outside of Western countries, if you look at places like Dubai in the UAE and others, is that beyond the arbitration community, there has been an effort of the judiciary to promote a safe seat. And by that, we don't mean a seat that would accept any arbitration award, but a seat for which the rules are clear, for which the judges understand what their role when it comes to arbitration is and what it is not. A seat for which also the decisions are published and accessible. And when I say accessible, of course, I know that many courts do, if you contact them, they will give you the decisions that are rendered there. The point is that there's a responsibility from I would say this time around, the arbitration lawyers and the arbitration community in general in Africa to actually spread the decisions that are being made in African seats whenever those decisions are showing a favorable approach to arbitration, or at least in line with international standards. Because that is, if you ask parties who are engaged into our international arbitration, what they're looking for is not the perfect arbitration in a venue in Paris. You are correct, Barbara, when you say that what does London have that we don't have in Kampala, in Nairobi, or in any other venue in Africa. So the parties are not looking for a fancy place or whatever, and most likely some of them would feel that the fancy place is actually in Africa. What they are looking for is to make sure that the outcome of this dispute, this piece of paper that the award is, will be enforceable. And that is the driver in choosing a seat. And in most of the case, the reason not to choose African seat is related to lack of understanding of the capability and the ability to enforce an award in Africa. So I think that at least after 5 years almost of doing this day in, day out, I'm realizing that the next step and the next focus should be on that specifically. Now, on my concluding remarks, just one point from me, which is to say that, as I said, I've been in this seat for 5 years as director for Africa at ICC. And actually, I don't think we should talk about Africanization of arbitration as something we are aspiring to. I do believe it's actually already here. And in a way, that's a bit of what Chizaram was telling us right before. We already see, if you look at those ICC statistics more closely, that you do have more than, the number of arbitration practitioners in ICC disputes sitting as arbitrator has multiplied by more than 5 in the last 5 years. Those are appointed by ICC and those appointed by the parties, which says something. It says that habits are changing slowly. It also says that the capacity and the talents that were out there on the market that maybe the communities did not know about and the clients did not know about are now clearly known, accessible, and identified. So things have changed. Institutions like ICC today count over 30 court members from African jurisdictions, which necessarily changes the way this institution is doing its decision-making process and necessarily Africanizes the decision-making process, because each of those 30 plus African practitioners take part in the decision-making. And it's the same for ICC's commission and so on and so forth. So what I'm saying here is that let's not talk about something that is far and impossible to attain. It is here already. The question is, how do we get even further? And that's where I like the idea that Barbara has mentioned about, intra-African capacity building, secondments and others. I think that is really important. And the last point for me is that, of course, even with my ICC hat, I do promote arbitration before ICC centers. Why is it essential? Because that's how business communities get acquainted with arbitration and move towards international disputes, is when at a local and regional level, they actually go to arbitration. You will see that in London, New York, Geneva and Paris, there are very strong regional centers and local centers of arbitration. So one does not exclude the other. Far from it. That would be my closing remark here.
Thank you
very much, Anne, and thank you everyone for having me.
Thank you so much, dear Mana. The panelists have sounded the gong so loudly that we need to advertise our wins as Africa. We need more viable arbitration centers. And most importantly, the world needs to know that a court, an award when presented for enforcement before court, there'll be limited or no interference. That is how Africa will be the most viable and the most preferred seat. Thank you so much. A big round of applause for all our panelists again. And enjoy your remaining session. Over to you, Kenneth.
Thank you very much, Anne. Another big round of applause to Anne and the panelists. Kindly, I'll ask the guys in the media to actually play for us a song, an African one or a Ugandan one, as they come down. Excuse me, I'm also advised that we need a group photo. I don't know how I'll get the guys online, but I think we can take, and you can take your seat in the center as we get Afrigo starting, and then we can take the photographs, the group photo. The cameraman, where are you? I believe you. Okay, fine. The online panel is also joining us. I don't know how the screen, can we do a split? Oh, excellent. Okay, fine. Kindly split and then we can have the photo. Yes, continue the music. The photographs won't have the music, don't worry. We have the split screen. Oh, they've gone. Okay, fine. So loud one in the house. Kindly. Okay, thank you very much. You can now step down. Thank you, Anne. Oh, okay, fine. One more. And I like this song. Where will you get my Fabian Ken? Okay, thank you very much. Thank you very much. Fine, you can walk down. Another round of applause as you walk down. Thank you, thank you, thank you. I think key takeaways are number one, we are selling Uganda today. We are marketing Uganda as a favorable seat and also venue for arbitrations. I'll give you a small hint of how I ended up in arbitration. I attended a conference, and because people knew me, those who were moderating, they said, Ken, can you tell us the difference between a seat and a venue? Behold, I described the seat and the venue as one and the same. And that got me into thinking, okay, I think I don't know certain things. I need to jump onto this thing. And I jumped on hard because I went all the way and did the membership course for SIAP. Quite unique also because there was a lot of reading, and I had last read, I think, after LDC. But it was quite intriguing. So members in this room today, I encourage you to take a step of faith, prepare yourself, and apply to at least become a member of the Chartered Institute of Arbitrators, the UK. Fortunately, we have run the race a bit, so we now have a chapter in Uganda. I am the honorary secretary of the Chartered Institute of Arbitrators of Uganda, so I must still make a pronunciation that we need you guys to enroll. We attended a conference where they asked us why, it was about justifying why Africa is not the preferred seat in the world. Why do people still go to England or UAE? And the takeaway was, Africa needs to prepare. We must be equipped with the necessary skills to handle these international arbitrations. And I can report now that Uganda has already prepared itself. We have over 52 members of SIAB, UK, over 52. We are set to become a branch. We're supposed to become a branch this year of SIAB, UK, but a few technicalities here and there on filing reports and then getting a report from our parents in Kenya, because Kenya is our parent. So we are waiting for our parents in Kenya to submit our financials, our business plan to justify that actually we can run independently without any funding. So members in here, if you haven't yet taken up the course, I encourage you, embrace it. Start, apply. There's a sitting in November. I think you're late. But next year we'll roll out a calendar, and I can assure you it is beneficial for us to be ready. So prepare, prepare, prepare if you're going to be its seat of choice as Uganda. Ladies and gentlemen, we now move to our second panel. Because of time, I will not allow you to have another music interlude. Otherwise, you'd love to listen to more of Afrigo, Olimujawa Msajo Mulungi Nganza. Definitely, being a man with the African Women's Conference or Symposium like this one, you'd want to sound your gong more by playing more of Afrigo. But ladies and gentlemen, I welcome our next panel, but I will not invite them. Instead, I will invite the moderator, who is none other than Mariam Iga. Mariam Iga is a professional with many years of diverse experience in the fields of academia, alternative dispute resolution, management consulting, procurement, and project management. She's versatile, accomplished, and recognized certified professional by the Chartered Institute of Arbitrators of the UK, the Chartered Institute of Procurement and Supply Chain Management, UK, the Institute of Public Partnerships, US, the International Center for Arbitration and Mediation in Kampala, an associate consultant at the Uganda Management Institute. Mariam has availed her professional advisory services across public, private, and other domains in context of management consulting to corporate entities and government agencies. She is a thought leader and passionate about creating awareness on sustainable issues, be they focused on social, environment, or economic stability. I can also say that she also sits on the Education and Training Committee of the Chartered Institute of Arbitrators of the UK Uganda chapter. She's also about to be co-opted in the Construction Law Institute because of her bias on environment. Ladies and gentlemen, let's clap as we welcome Mariam.
Thank you very much, Kenneth, for that lovely introduction. Good evening, ladies, and a few brave gentlemen in the room. Welcome to the second panel discussion, where we'll be talking about the second half of the theme for the symposium, which is diversity in appointments in international arbitration. By way of opening remarks for this panel discussion, we would like to appreciate the preceding panelists who did a very good job of breaking down the technicalities all around arbitration, that is the seat. And from a management perspective, they've done very good and done very well to help us differentiate and navigate the nuances around the seat, that is the place. The process is already laid out for us in the regulatory frameworks around ADR, and the panel that is coming on is going to help us deal with the people aspect in arbitration. Clearly, as speaker after speaker has spoken, there are gaps, there are issues when it comes to appointments in international arbitration. And just to be clear, so that this forum is not mistaken to be just a women's forum, the diversity issues we are going to address in this panel discussion don't only limit our discussion to gender. We would like to make it clear that diversity is all about equal opportunity. The statistics are very, very clear. We have moved the conversation and the narrative from just saying, Diamara always talks about appointments where we used to fight and just say, we want a woman representative. And then we'd say, okay, now we have a woman, but we have 7 gentlemen. But we want to see the equal opportunity moving from percentages where we have, for example, between 2015 and 2021, the percentage of female arbitrators sitting on arbitral panels internationally rose from 12.6% to 26%. It looks like a big leap, but is 26 the ideal? Then when we go to other forms of diversity, we talk about age. It looks like a small matter, but how many arbitrators are overlooked because of what their birth year is? We all know the narrative around race and ethnicity. Barbara just talked about geopolitical location of arbitrators. So let's be open-minded as we discuss the diversity issue in appointments and open our thinking beyond just gender to focus on all the issues regarding diversity in appointment. I am not an expert at all, and my work here is to facilitate the experts to discuss this sometimes very inciting discussion, but we'll try to keep it within the lines of having a reasonable dialogue so that we come up with resolutions that will carry us forward in meeting our goal. The goal is no longer to promote diversity. I think there's enough initiatives around promotion. We heard about OHADA when Diamara spoke. Shizaram talked about other initiatives like the Pledge, the Arab Pledge, the ERA Pledge. There are so many, there's no shortage, as we are going to hear. But the goal is not to just talk about promotion, but to really actualize the appointment in a diverse way that produces a cross-section of underrepresented practitioners so that we can create a win-win. And to help us in this forum to appreciate and dissect the diversity issue, we have a very distinguished panel that I'm privileged to introduce to you. The first, in no particular order, is Aisha Abdallah. Aisha is a partner at ALN Kenya, and she's a leading regional dispute practitioner in Nairobi. She's dual qualified as an advocate in the High Court of Kenya and a solicitor of England and Wales. She has extensive experience in complex cross-border disputes. Aisha joined the Nairobi Center for International Arbitration in 2022, became the head of the governing council of the HKIAC. She's also on the ASFA panel of arbitrators and involved in the Singapore International Arbitration Center. She sits on the board of advisors for many ADR-related bodies. Welcome, Aisha Abdallah, to this panel. Next, we have Lady Justice Monica Kaliejira Mjeni. Monica. Lady Justice Mugenyi is a Ugandan judge with 30 years of professional experience, largely in the public sector. She has first-hand experience in harmonization of regional jurisprudence within East and in the Sub-Saharan region, where her substantial experience in the legal aspects of foreign direct investment and having led diverse teams in negotiating closure of cross-border privatization and divestiture transactions. Her resume is very, very long, and we want to welcome her in her capacity. And she whispered to me just as we started that she loves this fora because she can just speak as Monica. In fact, she has given me permission not to call her Lady Justice because she wants to speak from her heart as a woman in ADR. So welcome with me, Monica Kalejira. The next distinguished panelist is Madeleine Kilei. Madeleine is coming from Tanzania. She's joining us online. Welcome, Madeleine. Karibu sana. Please unmute. Please unmute.
Asante sana. Asanteni sana.
Yes, welcome to this symposium. Madeleine is an expert, a legal expert, a Tanzanian arbitrator with extensive experience in commercial and corporate law. She currently serves as the Tanzanian Institute of Arbitrators president and is renowned as the first woman in Tanzania to launch an online dispute resolution platform, which is right behind her. That is iResolve in 2015. So she has quite a decade of resolving disputes behind her. Madeleine's expertise spans across corporate and commercial legal support, counsel for domestic and international arbitration, commercial mediation, and a true leader in the field of dispute resolution. Thank you very much for joining us. You're welcome to this symposium. Last and definitely not least is our very own Olive Zale Otete. Olive is a fellow of the Chartered Institute of Arbitrators UK. She's an advocate of the High Court. She's an advocate of the High Court and has been involved in drafting international legislative and consultative papers. She works as a legal consultant with Justicia Law Advocates. She holds loads of qualification in the legal and in the ADR space, and has had many roles, especially coming through the ranks from a state attorney up to the last rank of senior commissioner when she left public service to start private service. She has also served, this is a very interesting, because we're talking about diversity, as you'll see the value in having a diverse panel, as the chairperson of the PPDA tribunal, which is concerned with dispute resolution in the procurement and supply chain space. And outside of this legal and ADR space, Olive's life mission is empowering people financially. She actively works for work-aid communities in and around Kampala and outside, and encourages people to join in the bid to fight poverty. So she's really one of the best persons we can have when we talk about equality and diversity in as far as ADR is concerned. So thank you very much, panelists, and we look forward to having a very, very, very open discussion on a matter that concerns us all. And because we have already talked about the seat, I request that I take my seat. This panel will have it while seated. So welcome, panelists, and this panel is going to discuss diversity in appointments, international arbitration, as earlier indicated. And the first question is going to be really to get a feel of your experience, because the diversity discourse in international arbitration has remained largely one-dimensional, focusing on the need to provide fair opportunities for arbitration professionals from historically underrepresented constituencies. Please share your personal experience in the diversity issues you've encountered on your journey as a female ADR practitioner. Please feel free to share both the highlights and the dim lights for context. This is a general question. Maybe we take 2 minutes and go around, starting with Monica, and then we'll go to the real gist of the matter.
Okay, thank you. Thanks very much. Can I call you Namza?
Yes, you can.
Okay.
Yes. She wants to call me Nanza. Nanza is my name.
All right. Okay, in terms of the historical perspective, I've read somewhere that historically the arbitration space was dominated by a group of people that can be characterized as stale, pale, and male. I'm sure some of you have heard about that, and that translates into elderly Caucasian males. So that was the predominant group in the arbitration space historically. And automatically it knocked out African men, African women or all women, and young arbitration practitioners. So that's the starting point. Now, when it comes to Africa in particular, most of our ADR is rooted in a traditional dispute resolution mechanism that was steeped in patrilineal cultures. And because of these cultures, women were not involved in dispute resolution. So again, the African woman is eliminated. My experience has been, in terms of the highlights, numerous African women have undertaken extensive training in arbitration and ADR, and they are ready to take their place in the arbitration space or in the ADR space at a larger level. However, they have been dogged by cultural and institutional barriers that prevent them from contributing meaningfully. I'll give a case in point. I served at the East African Court of Justice, which, like the COMESA Court of Justice, has a dual function. It does both arbitration and litigation. However, because the male club, I was the only lady at that time. However, because the male club was determined to compete favorably with its Caucasian counterparts, they too were trying to take up a space in the international arbitration industry. So when it came to nominations, which were done by the president of the court, the only female was never nominated. But being the female that she was, she kicked up a storm and eventually got one nomination. So if a lady is neither visible nor audible, if you have a lady that is shy and can't speak up and is not visible either, it's very unlikely that she'll land an appointment in these sort of circumstances. So in a nutshell, women are at a disadvantage. They could have benefited from institutional appointments, but even then, because of the lack of experience, party autonomy dictates that more often than not, parties are more likely to appoint a male arbitrator over a female. So because of that, they operate from a very disadvantaged position.
Thank you very much, Monica, and I applaud your bravery of calling out the PMS in the pale male's tale. I didn't have the courage, but anyone who's been around arbitration space long enough knows about that PMS. Would like to invite Madeline in from the virtual space to share her first-hand experience as a female practitioner. The highs, the lows. Madeline?
Thank you, Nanza, and thank you for having me. Thank you to the African Women in Arbitration for having this opportunity to share our stories, our experiences as women. And indeed, the PMS syndrome, thank you for putting it forward. So I will take it a further step forward in sharing my experience as a female ADR practitioner coming from Tanzania. Women were recognized as a symbol of power already. And to count, when I started off my career, the challenge that I faced was the fact that we had this club that the previous speaker spoke about, this closed club of members who are predominantly male. Now, this is the experience that I had, especially coming from an in-house position, having been working in an in-house corporate as a legal counsel in an in-house team, and taking that step towards private practice, and not only just private practice, but private practice with concentration on arbitration and ADR. This was a big challenge, I must say. Although it's not a unique journey at all, I'm not saying it's a unique journey. And so to leap or to jump over the hurdles, I think it's rightly put, there needs to be that courage at the very onset, once you have your ambition to pursue a career in arbitration and ADR. And so that's my take on my journey in terms of the experiences as a female in this practice, having started about 10 years ago, as you've noted from my resume.
Thank you very much. Please go ahead.
It took consistency in all seasons. All seasons required this consistency of hard work, commitment, and perseverance. Perseverance in breaking that barrier, that wall that was contained of predominantly male practitioners. So I'll leave it there. Thank you, Nanza.
Thank you very much, Madeline. We'll hear from Aisha what her experience has been so far. Dual qualified, UK and Africa, and many years and many jurisdictions later.
Thank you, Nanza. So the first thing to say is that diversity is a global problem, and I faced challenges in the UK where I practiced for 12 years, as well as in coming back home to Kenya and to Africa. So I think it's important for us not to accept a label that somehow this is an African problem. It isn't. And then the second point to make is that what is often used as an excuse not to have a diverse panel is this word E, experience, and TR, track record. So trying to break into this club, it was very hard, because what people would say is we're looking to appoint people with experience and we're looking for a strong track record. Now, of course, if you've never been given the chance to play on the field, you will not gain the experience and have the track record. So I felt that for me, my biggest challenge was to essentially be able to break in and get my first appointment as an arbitrator, which I did through an international center. And I thought it was interesting that a center that had no link to Africa was prepared to appoint me, and maybe people closer to home were more hesitant. So I think one thing I would say is that the PMS people, the pale, male, stale, one of them adopted me. So I have a very good mentor who's a KC, and we just bumped into each other one day in Mauritius, and he decided he liked me, and essentially, he said, "Have you been appointed?" And I said, "No, I've only ever been counsel." He says, "I'm going to fix that." And I think the sad reality is that you do need to find allies within the PMS and outside as well. The PMS are very important because, to be honest, the way they appoint each other is that they just have a chat, and it's not a formal process. Oh, I bumped into Edith at my, my all-male club in London, and, she has availability, so I'm going to appoint Edith. And literally that's often the way it works. And then there's some sort of email that suggests there's formality, but there isn't, honestly. So I think look for allies, and don't look for allies just amongst people who look like you. Look for allies amongst people who aren't like you and do represent power, because those are the most people likely to be in a position to facilitate your career. And I think one of the lowlights would be the idea that an appointment is made as a token. I think I find it very disrespectful to this panel to suggest that you would only be put there as a token and no one is actually expecting you to play a role. So I think when you are given that chance, even when you suspect that the motives are not as good as you would like, you must play the role that Judge Monica said. You must you must seize the opportunity, you must speak out, and you must be super active. And no one should be able to say that that they did not hear from the woman on the panel. Thank you.
Thank you very much, Aisha, for that brave sharing. And it looks like PMS is going to be our word, but I warned you about this panel, so brace yourselves. Olive, what has been your highlight, dim light, your experience?
Thank you very much for this opportunity. My experience will be slightly different. Actually, I have encountered a lot of support from the men. When I joined the tribunal in 2014, the tribunal consisted of 5 people, and I was the chairperson, and the 4 were men, and they were incredible men. I had a lot of support. So through the 6 years that I led the tribunal, first I want to say this, sometimes as women, if you enter with this thing that I am a woman, and whatever I say, if my colleagues object, they're probably doing so because I'm a woman, then you'll have a challenge. But if you enter your work as a professional, competent and qualified, you will talk to your colleagues as professionals. And so for me, throughout, I never actually ever had that thought, even once, that in case there is disagreement, and we had a lot of disagreements in the tribunal, especially when we are handling cases, I knew that they're disagreeing with me because of this and not because I'm a woman. And fast forward to the arbitration space, I was actually mentored. I was introduced to arbitration by a man, and please permit me to introduce Counsel Albert Mukasa. Please, Albert, stand.
He's our guest of honor too.
Yes, Albert Mukasa is much younger than me, but he's the one who said, you have been resolving disputes at the tribunal, why don't you join arbitration? So I am in this space because of a young man. So I'll stop there.
You can see diversity in age.
Diversity in age.
Yes.
So yeah, I'll stop there.
Thank you very much, panelists, for that frank introduction to your personal experiences. And because we are in Uganda, but represented by a very able legal head from the Supreme Court, even though she doesn't want to associate, we are going to set the stage with, or let me call her Lady Justice Monica, for this particular segment, where we are going to talk about the legal landscape, basically. There's no lack of initiatives, as speaker after speaker has said, especially in the concluding remarks, Diamara, Shaziram, everybody, Michael, the initiatives are there, OHADA, REAL, we have the ERA pledge, we have the ARA pledge. There is no lack of initiatives to support diversity. And again, for purposes of this forum, we are not talking about gender diversity only, we're talking about all forms. But the question will be, in your experience, what do you consider are the major hindrances? If the goodwill is there, at least on papers, why aren't these initiatives meeting their objectives as fast?
Okay, from the African perspective, I think we need to understand, in a sense, that yes, it's been said that arbitration has been here for a while, but not as long as it's been in the Western world. So we are dealing with a section of men that are themselves trying to penetrate. I'm talking from the gender perspective. They are trying to penetrate the international arbitration space. And so it's not likely that they're going to make it as easy as was done for my colleague here. Having said that, I think women need to be more visible. It's not always easy to be as visible as we'd like, but these sort of forums give women talking engagements, and through the talking engagement, you are identified, like Aisha said. So once we have this visibility, then we get to that thrust of what arbitration is about. The nature of arbitration is that it's a private process, and the privacy of that process in itself creates challenges. For instance, it's very difficult to tailor diversity messages, like these initiatives are trying, without supportive data. However, the privacy of the arbitration process will not give you enough data to indicate where there are gaps among arbitrators, so that you can say maybe a younger arbitrator would probably have been more conversant with AI issues than a more elderly arbitrator. We don't have this sort of thing because of the privacy of the arbitration process. Then secondly, the finality of the process itself. If I'm going to go for arbitration, which is a final process, we are hoping there will be no challenges and the award will be final. If that is the context within which we're applying, put yourself in the shoes of the parties. Any party would want to hit the ground running. So experience comes in. They'll be looking to the PMS, the experienced, pale, male, stale person, unfortunately. So these are some of the hindrances to whatever initiatives, whether it's along gender lines, whether it's along ageism lines. These are the hindrances to the diversity messages. Finally, I think I'd like to talk about arbitration laws and rules themselves. We have an opportunity to reform our laws and make them more intentional about the diversity argument. We have many of the partner states, many of the African states, my mind is still in many of the African states abide by the ancestral model law. That model law prohibits exclusion on the basis of nationality. That's the only specific exclusion that it highlights. I think it would help if more laws or arbitration rules specifically highlighted diversity issues. We have national constitutions that specifically talk about discrimination on the basis of religion, on the basis of tribe, on the basis of ethnicity, on the basis of gender. These sort of things might enrich the rules and make it crystal clear that whatever arbitration panel that you're trying to set up should have some diversity element or some diversity context in it. So I think that would help, because we tend to be basically rule-oriented or law-oriented. So when it's spelled out specifically in a rule, it tends to be more accepted than if you're simply agitating or trying to advocate for diversity at this level. That would be my take.
Thank you very much, Monica. I think you have brought it home for us, because our goal this evening is to find practical ways to move from just promotion to actualization. And we are blessed that within the region, as we were discussing earlier, that our rules are not yet cast in stone. There's lots of legroom for reforms and all that. So it's a blessing in disguise that we are led to this party, but it allows us to do things in a way that serves us well. So thank you very much. And we hope that this conversation will be carried beyond this room where these changes can actually happen. We'll go straight to Madeline. Madeline, we would like you to help us understand and appreciate the issue of bias in resolving bias in appointments. The issue of bias is a resounding theme across arbitration, in the arbitration space really, be it in the macro institutions where appointments happen or in the ad hoc. There is a bit of bias in appointments without a doubt. What are the common biases to appointment of arbitrators that you have encountered across the different jurisdictions, and how best can you overcome them? Madeline, over to you.
Thank you, Nancy. I'll just put my camera off because I could not hear you properly. And thank you for the question. Indeed, bias and human bias is really a result that comes out from having an ideal candidate for the task at hand, whether be it a sole arbitrator role, presiding, or as a co-arbitrator. Now, why is it important? There is the principles that are fundamental to arbitration: independence, impartiality, and party autonomy, of which some of the speakers have already touched on. These are the hallmarks of an effective and fair arbitral proceeding. Rules against bias is one of these fundamental principles. And these are natural justice principles, which apply to not only judicial, but also quasi-judicial proceedings such as arbitrations. And so lack of independence or impartiality on the part of the sole core arbitrator or president or any member of the tribunal may end up constituting to a ground to challenge their mandate or jurisdiction over that matter, and or challenge the arbitral award, which is the end result of those proceedings. Now, if we look into our national laws in the region, for example, none of them define this term bias or partiality on the part of the arbitrator. But if I go to the closest that I can get to the definition would be in our Arbitration Act, for example, if I can recall Clause 28 of our Arbitration Act, the revised edition of 2020 in Tanzania. It talks about circumstances that may give rise to justifiable doubts as to the independence and impartiality of an arbitrator. Now, what amounts to justifiable doubts is not expounded on in that section. But the instrument that we usually use are instruments to guide us, such as the IBA rules on conflicts of interest in international arbitration. And so, to start off, I do agree with you that this issue of bias is a resounding theme across the board when we're speaking about arbitration. Now, to speak on my experience, what I've encountered, or the common biases in the appointment of arbitrators that I've encountered during my career, I would maybe try to just give you a few, and I would refer to them as the AACS. That would be affinity bias, affiliation bias, cultural bias, and the stereotype bias. And these are echoed across different jurisdictions that I have had an opportunity to experience. I'll give you one example of one of the biases. For example, cultural bias. Cultural bias, it does not have to be meaning in terms of the cultures, but we can speak on the level of the differences between civil law and common law differences, and the issues that one would encounter, especially that we come from common law jurisdictions most of the time. I had the opportunity to act as a presiding arbitrator in a matter that was administered by the CIRCURCA, which is the Cairo Regional International Arbitration Center. Now, under the CIRCURCA, we have rules which were familiar to me. However, that particular contract was governed by Egyptian law, and the seat of arbitration was Paris. And so these can lead to a lot of challenges on the part of the arbitrator if the arbitrator is not self-aware. Is not self-aware or making themselves to the attention of these differences. Hello, am I audible?
Yes, we can still hear you, Madeleine. Go ahead, please.
Yes. And so sharing that experience, I've also shared already the aspect of the fact that there are biases that are most aligned to affiliations. And when I say affiliation, is that we're most, at the time, we're more comfortable suggesting names that are, of persons that we have encountered, that we know of, that we sit and have drinks with, So we see this to be an issue, and I've seen it happen in my experiences in terms of the appointments, some of the appointments that I've had. For example, with affiliation, the good example that I had is that I sat as an arbitral secretary in a matter. And in that matter, there was a well-rounded tribunal, and the chair took liking to the fact that I was able to manage as an arbitral secretary and support the tribunal with the competency that he had expected of an arbitral secretary. And so that affiliation led up to an appointment as a sole arbitrator in a matter that he was sitting as counsel. And so these are some of the common biases that I've encountered throughout my career. Now, how do we overcome these situations or these common biases that I've spoken about? One example is the fact we're speaking up about them. And yes, we have been raising our voices, and I agree, it is now time to actualize and put in action and walk the talk, as put forward by the moderator. We have acknowledged that there is bias in appointing African practitioners. We've also realized that social media can be of great assistance to overcome the perception that women or African descent arbitrators are non-existent, because at some point, for example, from the region, we were somehow not existing. And so that raises our profiles, being able to voice up our abilities to the community at large. And it's a small community. I mean, this arbitration community is not as vast as we think it is. It is a very small community. And so consistency again and persistency in our approach to vocalizing and actioning our self-ambitions, our track record, as Aisha has put it. This is an important key to overcoming these common biases that I've tried to touch on in my presentation. Another issue that really helped me, sorry, I'm just concluding on my points there, Nanza, are mentorship opportunities. And I would say that this is the key to ensuring that we raise profiles of those upcoming younger talents that are begging to be able to be mentored in this space. We're not only speaking about the women agenda, we're speaking about the age agenda. And profiling these talents is very important through these mentorship programs. And we've seen the African Arbitration Academy also come up with the young practitioner sort of award, where we're recognizing that, yes, young talent is welcomed and that there is a roadmap for them. I think in the country here, we've seen universities also be able to take up students and have well-structured programs for them. And the Tanzania Institute of Arbitrators has played a major part, along with donors, funding that program to ensure that we have this sustainable sort of pipeline of practitioners coming up in the near future. I think just when I'm concluding my presentation to you, is the report that I came across when I was preparing for this session is the usual suspects decision-making in arbitration selection by Cortex Capital. It's an October 2023 report, and I would wish for participants to look up for that report. It gives very good recommendation on several ways to improve the decision-making process around arbitrator selection. And it speaks of most of what I've highlighted, but adds on top of these, including Justice Monica's comment with regards to arbitration rules, accommodating diversity, and they highlight the fact that this is a driven agenda globally. And I've seen institutions such as the Hong Kong International Arbitration incorporate a rule that is speaking to the diversity issue directly. And I think this will be something of a leaf to borrow from, Nanza. Thank you.
Thank you very much, Madeleine, for that elaborate, transparent, open conversation around issues of bias. There's no need to repeat everything you've said. We appreciate the success stories. You've answered actually 2 questions in one, so it saves us a bit of time that is fast running out. And you talked about the different academies, the different institutions, and how they are shedding light. And one of the success stories we have is right with us in the room. The African Women, this very institution won an award at the AAA, the African Arbitration Academy, in the category of innovation. So the glass is half full. The glass is half full, it's not half empty. Quickly we'll turn to Aisha. We are going to speak about the power dynamic. There is no way we are going to address arbitration without touching on the power dynamic in the space. So when it comes to investment disputes, Africa finds itself caught in a terrain of historical power dynamics between funders and African states, with most projects taking on standard form contracts and ensuring that the arbitration clause is dictated by the funders. Michael mentioned it a bit in his discussion. So where there is confluence, should African arbitrators consider then, just to manage this power dynamic that is ingrained in the very space that we play?
Thank you. So I think that's an important imbalance. The first thing is accessing some of the capacity building that's being offered by people like the IFC and the World Bank to assist African host states better negotiate their contracts. That's number one, capacity building. Number two, I know, for example, that the Law Society of Kenya lobbied one of our previous governments to say that there should be a policy where every time the Kenya government is sued by an investor in a dispute, the Kenya government must have a policy where when it onboards external counsel, there's an obligation for skills transfer and capacity building for the Attorney General's own staff. And actually that worked really well under our former Attorney General, Professor Gideon Muigai. And it happened that they were able to, over time, steadily reduce the scope of the external counsel's role and increase the role of the own Attorney General's people and build the capacity, not by losing cases, but basically by learning on the job. So I think that's a good thing. That comes from lobbying and political pressure. The other thing is that we cannot expect as Africans to be appointed by foreign parties. I think that's not reasonable. I have no expectation that Chinese parties will appoint me. I would be very surprised. I think that what we have to do is start at home. So fix our home, which means that we must push our own Africa centers. We've got Nairobi Center, there's Kigali, Tanzania has a center. I mean, there's so many centers. There's 74 in the continent of 54 countries. These centers must be lobbied and pressurized to make first-time appointments of African practitioners. That is first-time appointments. So that means, I know there's this thing where there are only 4 Africans and it's only those 4 who are appointed. That's not what I mean by diversity. I mean first-time appointments, young people who don't look like us, people who aren't presidents of Chartered Institute. Those are the type of people who need to be aided with first-time appointments. And then I think the other thing is, for example, the ICC actually make first-time appointments and they report on this. They report on it. Hong Kong Center make first-time appointments. So when I asked Diamana, how do you get a first-time appointment? She said, what you have to be is you have to be a member of good standing of the National Committee for the ICC. So the ICC in Paris will never appoint a Ugandan who is not a member of ICC in Uganda. And not only a member, you have to be in good standing. So that means if ICC are holding events, you should participate and you should be active. And that way, when the Paris office asks the Ugandan, branch, can you recommend somebody for this dispute where we're looking for whatever reason for a Ugandan, and normally it's because there's a party that's not participating, so ICC is making the appointment on behalf of the party, then you should be in a good position to be recommended. So I think there are practical things you can do, but please, let's not start lobbying in Geneva and London. That doesn't make any sense to me. I think when we lobby, we should lobby at home, and when we increase pressure, it should be through groups like the Law Society and the Chartered Institute on our own home turf. Thank you.
Thank you very much, Aisha. That is a very practical way to carve out the issue of the egg hen, because everybody is looking for a fast appointment to have a track record, and the cycle goes on. And that feeds into our next question to Olive. Olive, who has had the privilege to work with lawyers and non-lawyers, and is now a private practitioner as a consultant, meaning you are working with non-legal people in the ADR space. This very ADR space has opened up to other pathways for professionals besides legal practitioners. We have engineers, we have architects, and some of them are in the room, we have surveyors. So what advice do you have for non-lawyers who would like to position themselves in the international arbitration space? Non-lawyers.
Thank you. My answer is not going to be so different from my colleague. My theory and my proposition is that before you aspire to go to the international space, be good in the national space first. First, be good at home. So you're an engineer, you're an architect, you're a surveyor, and you have passion in arbitration, and you have undertaken the training. First and foremost, do you have stature, sufficient stature in your own profession? Are you in good standing with your own professional body, the Engineers Registration Board? Or do you have disciplinary matters there? Have you eaten clients' money? You have not completed clients' work. So the first is have stature in your own profession. Then second, undertake the professional training in ADR. And of course, in this room, we're talking about arbitration. Most of us, I think, have done the Chartered Institute of Arbitrators course. It's a very intensive course, almost 2 years, and it has levels. My advice would be start from associate and go all the way up to fellowship. I see that most people stop at member. I would encourage that you do the last one. It's quite intense, and it teaches you how to draft an award. Because in arbitration, the parties are looking for an award, not so much the process. So if you stop at member level, you've missed a very important step. So my advice to the non-lawyers in ADR space is undertake the professional training, and then undertake some other forms of ADR. We shouldn't only be arbitrators, we should have some professional training in mediation, in adjudication, so that if a client comes to you, you're able to give information on the other types of ADR other than arbitration. My other advice would be undertaking continuing education to actually all of us, not only the non-lawyers. There is always a lot of courses by SIAB, Kenya branch, by all over the place. So we should look out and undertake those courses so that we are on top of the game. We understand what the emerging issues in ADR. So continuing education. Then, does your own society know you as an ADR professional? That is a very good starting point. The Society of Architects is holding an AGM. Try and find a slot, even for 5 minutes, to talk about ADR. Let your own people know, because otherwise, how will you ever get work? For non-lawyers, the climb is even steeper to get appointments on panels. So you have to start with your own society. Let them know, I am an architect, I'm a surveyor, I'm an accountant, but I'm also qualified, competently qualified in ADR. So you increase your chances if your own society know that, oh, he's one of us. In case of any issue, you're most likely going to be sought after. The other advice, of course, increasing visibility. And how do we increase visibility as arbitrators? There is writing. They're always calling for articles in journals. But do we find time to say, let me write in my space, what are the issues in the survey field? We have a lot of issues with land in Uganda. You are a real estate agent. What are the issues there? If you can share by writing, then we get to know that, oh, there's so-and-so, he's a real estate agent, but he's also an arbitrator, he's a mediator. And then not only at the national level, but regional. I always liken this space to flying. If you're learning to fly, they will not give you a Boeing to fly across the Atlantic. If you've not flown to Arua or to Nairobi or to Kilimanjaro, you have to first fly in your space. So arbitration hours, I've been doing arbitration since 2022. You actually must gain by the number of cases that you arbitrate, and each case you gain experience. So as a non-lawyer in the ADR space, you must actually get appointments. You must do arbitration either as a member of the panel, so that you gain experience and confidence. So people shall believe that, okay, you can do it. Then we have a Chartered Institute of Arbitrators, Uganda chapter. All of us in this room, we should be members. We should grow our own chapter, first by doing the training, because to be a member, you must have the professional training. So let's do the training, and then we become members of the Uganda chapter. Because if you look at Kenya, the Kenya chapter it's our parent, and I think they're growing arbitration because they have so many members. When I was doing the training as an arbitrator, this Chartered Institute, I was with an architect. We did the course together. But each time I check on her, she is so busy. Cases are killing her. Right here, you're just waiting. You get? And why? Because the Chartered Institute of Kenya has really done a great job in marketing. It is visible. So, and that's the lesson we should learn as Uganda, that let's be visible. Let's go to these institutes. Who are the suppliers of arbitral cases? The Chamber of Commerce, building and contractors, insurance. Those are the cases in court. So those are the clients. So we need to increase our visibility by engaging with them and teaching them about ADR and how it may improve their business interests. And then last but not least, diligence and thoroughness once you've been given a work. We're talking about initial appointments. If you're lucky and you've given an appointment, how have you handled it? If you mess it up, who will ever appoint you again? So diligence and thoroughness in the way we do our work as arbitrators is extremely important. Mastering the facts of the case is the number one factor. Then, of course, ensuring an effective process, making sure that the parties are being treated equally, and of course, last but not least, technological competence. I'm handling a case right now where we are having a hearing. I had to be very humble and tell the parties I am very challenged technologically, so humility is also part of the game. Don't pretend and then you reach the hearing and you fumble. So I told the parties I will need IT support. Do you allow me to hire an IT person? And they said, yes, Madam Arbitrator. So I have an IT support. So humility is very important in this. It's a thing that the environment can change anytime in the duration of the matter, so you have to be very open to the parties. Last but not least, non-lawyers in the arbitration space should enroll with our arbitral institutions. In Uganda, we have two. We have ICAMEC, we have KEDA. Imperfect as they might be, we have to enroll. Otherwise, how will they know that you exist?
Thank you very, very much, Olive. In the interest of time, she has been very elaborate, and we would like to thank her very much for that insightful advice. We would have loved to continue with this panel, but because of time, we will give just 2 questions. We have had professional diversity. We will have participatory diversity for just 2 questions to any of the panelists. They will give their parting shots, closing remarks in a minute. And then if there are any burning questions, because the whole essence of this symposium is to have recommendations we can carry forward, please reach out to our secretariat. We will take note, we will respond. If it is to a particular panelist, we will get them to respond to you using the technology that Oliver has just spoken about. And we will make sure that the conversation goes on beyond the 3-4 hours we've had in this room. So we'll have, Kenneth, please, 2 burning questions, and then we'll have parting shots because one of the panelists has to fly back to another very important international engagement.
Question number 1, where? I'm roving around. Oh.
Please speak the mic, speak eloquently and briefly, and if it is to a particular panelist, name them. Thank you very much.
Thank you. My name is Namrasa Rashida. I'm a valuer. I'm a non-lawyer. My question can be answered by any of you. As a non-lawyer, I've been given tips on how to become an arbitrator. I would like to be guided on how I can enroll to join the arbitration field. Thank you.
Thank you very much. I'm very able to answer that. And I kindly request that we have a chat in the networking event. Now we'll have the whole evening to take you through the 1, 2, 3. Thank you for saving our time. Any other burning question? Any other burning question?
At least from a man, right?
Yes,
diversity.
from a man, diversity. Or a young person who's not pale, male, or stale.
I think people are shy.
Anyone checking on the online audience? It could be coming from the virtual participants. If not, Madeline will give her closing remarks in a minute, and then we will try to wind down to allow the distinguished arbitrator to proceed with other international arbitration matters. Madeline, over to you for your closing remarks. But if there are other questions, the panelists will be around for the networking event that you can engage and ask one-on-one. Madeline, over to you.
Thank you, Ananta. Thank you, Mariam. And thank you for the questions from the floor. Indeed, there are many ways and many organizations, institutions that one can join in order to get themselves started. I believe that, of course, we can tackle that. And the issue that we have we've discussed today with support from each one of us, I think we can be able to overcome the challenges that we have heard, and of course tap into the opportunities that are ahead of us. My video is on. And so again, thank you for the opportunity to have joined this panel. We need to broaden the conversation. We need very much, I have not heard from my fellow panelists with regards to sharing experiences through publications. I think this is something that we are lacking, not only in the region, but on the continent. We need these conversations to be earmarked in publications as well. Additional to that, I think I find that data speaks a lot. We've seen the data coming in from the ICC, the 2023 report giving very positive increase in the gender space and the age space as well, and the ethnicity space as well. And so in our continent, we need our institutions, the remarkable ones that we've noted during the session, to also put forward transparently the data and have a standardized reporting with regards to the representation in tribunals that are sat and administered under their institutions. And so that's my takeaway. And karibuni sana, Tanzania.
Thank you very much. We appreciate that input. Next, we'll hear from Aisha, your closing remarks.
Mine is a general one. You know, there's a very good African proverb. If you want to go fast, go alone. If you want to go far, go together. I think as Africans, let's not make the mistake, or women, of fighting for a small slice of the pie. What we should do is together we should lobby to increase the size of our own pies, because sometimes you find yourself being told that there's a diversity space and it can be occupied, and you believe it can only be occupied by one person, but that's not true. It's not true that it is limited to one or a few of us. That space, if we were to combine forces, we could actually grow our own pie, and then you wouldn't even worry about appointments outside Africa. Thank you.
Thank you very much, Aisha, for teaching us how to expand the pie. Thank you for that lesson. Olive, your parting shot?
My parting shot is to encourage the young lawyers and other professionals to join the profession by undertaking professional training. Once we do that, then we shall assist in the long term this backlog problem. A professional who is aware of the values of ADR will never draft a contract without an ADR clause. Thank you.
Thank you very much. And to put a beautiful bow on this lovely discussion, we are honored to hear from Lady Justice. Again, when I call you Lady Justice, I'm calling you out in another level to put a bow on this conversation of diversity.
My parting shot, before I go to my parting shot, just to urge the leaders of the Chartered Institute of Arbitrators, the Ugandan chapter, that Uganda has no ICC committee. It's a shame on us. Kenya does have one. Uganda does not have one. I take every opportunity I get to encourage the active arbitrators to please come together and form an ICC committee, because it's from that committee that ICC will pull for appointments. So that's the first comment. Then secondly, to professional bodies generally, I think even as we aspire to get into the arbitration space, we need to look at our professionalism credentials. Arbitration is hinged on integrity. Arbitrators must be persons of integrity. If we do not have anti-corruption credentials firmly in place, we are going to derail the entire profession. So I urge us, all the professionals in the room, let us look at our integrity credentials, let us fine-tune them, and let us remember that the efficacy of this process depends a lot on the integrity of the practitioners. I thank you.
Thank you very much, distinguished panelists. Thank you very much, participants. You've been a great audience. I know if we had time, this is a conversation we could have till late. But we know that it won't stop here. We hope to engage on all our platforms. And at this junction, I thank you very much. And I wish all of us meet our objectives for coming for this symposium. I would like to hand the mic back to the MC and wish you all a great, great evening.
Thank you very much, Nanza, for moderating this panel. Definitely, I will re-echo the thank you, but also the photo moment is now. So I'll ask you to stay in your seats so that we can have our...
Madeleine, please don't leave. We need you in the panel photo.
If Madeleine can join, well and good. And we'll have a photo moment for... No, please stay seated. Because we'd want her to be part of it. I hope, has she signed out yet?
She's saying she's still there.
Oh, Madeleine, kindly turn on your camera. Madeleine, your camera. Fine, Madeleine has not joined, but I think her name is there. Her name is there, so I think we'll take it that she's there. But thank you very much. Kindly, I'll ask you to hold on a bit. I want to ask the the first panel also to come, and then we have a group photo for the first panel. Anne and your panelists, kindly. Aisha, we are still in time. So kindly don't leave Nanza. Barbara, you had forgotten? The camera lady and men, kindly allow after that, I'll ask Justice Olayo, I think, will join as well. Okay, fine. So I'll ask the entire judges who are here to join. Patience as well. Justice. Apologies for calling you by first name. I'll also ask the ED to join. Edith. Okay, thank you very much, Edith, for organizing us, to bring us in this room. Lady in red. So Edith is our boss, the ED. Thank you very much. Okay, fine, so we can take our seats. Before we take our seats, I'll ask Edith and Aisha to stay. We've just signed an MOU with Aisha, so I think we'd want a picture on that one as well. Kindly, Edith, you may take the MOU so that we can also take a picture moment. I'll ask Albert to join them. ICC. Justice Monica mentioned about ICC. Albert is the former representative of Young Arbitrators, Young Arbitration ADR Forum. So he represented Uganda, so he was holding our flag high on the ICC, representing the young arbitrators in ADR space. So Justice Monica, we have a representative from ICC, former chair or president of the Young Arbitrators ADR Forum. Albert is also instrumental in inviting many other people from different spaces to join arbitration. I think you've heard from Olive. In terms of building content for Uganda, Albert is a fellow. Can I see all the other fellows in the house? Fellows from SIAB, fellows of the Chartered Institute of Arbitrators. Justice Mugenyi, I think you're one of them. Yes. Olive, yes. Kenneth, yeah. Not Kenneth, Philip Kaher. Yeah, so ladies and gentlemen, we have content in terms of who can arbitrate your matters. So thank you very much. I'll also ask us to take cognizance of Albert. Albert this year also put Uganda again on the map. He won an award. He's an award winner of the African Construction Law. I'd also want to inform you that in terms of equipping Uganda on skill building, Olive informed us that we need to equip ourselves. We belong to, I and Anne belong to the Construction Law Institute together with Mr. Kaheru. Mr. Kaheru, can you put up your hand? Yes. Today I'll stress Kaheru with putting up his hand. Mr. Kaheru is a quantity surveyor, so we belong to the Construction Law Institute, and we do offer trainings in construction law. You will note that most of the dispute resolution clauses in all construction agreements either refer to arbitration, adjudication, mediation, depending on how the clause is tiered. So I would encourage you to tag along. I'll ask Bridget to put up her hand. Bridget is our administrator at the Construction Law Institute. Bridget also doubles as administrator at the Chartered Institute of Arbitrators, Uganda chapter. We are also rolling out courses, so I encourage you to go to your social media pages, like us, then you'll be able to see the content there. We'll be running several courses for introduction to ADR, introduction to arbitration, and also linking you up to where the arbitrations are or where the appointments are. I encourage women to attend. I will also close by saying, when it comes to liking pages, please like the Construction Law Institute. For one reason, the trainings are many, and it's why you'll get diversity in terms of appreciating the dispute, where disputes arise from. Many of us went to school, did law, did whatever, but we did not learn anything about construction. So whereas we know the contract between two parties, Curie versus Misa, Fisher versus Ingram, those kind of cases, those who are lawyers in the house, those don't apply in construction. You're looking at failure to deliver on time, which you may think is a sale of goods aspect, but it's not. You're looking at critical path calculations. You're looking at various aspects. So I encourage you to actually enroll and like. Yes, Justice Mugeni. Yes. Very good. We have a cocktail on the 8th floor immediately after this. It's our networking event, but also we'll be asking you for your business cards. Please don't feel offended. To be purposes of meeting the objective that we had today, to put us in one room, which is a WhatsApp group. We'll ask for your permission to allow us put you in a group. I hope nobody has an objection. By show of hands, we'll take nays and yeas. By show of hands, yes. Wants to be in a WhatsApp group? Yes, and who doesn't want to be in? I can see there are many who don't want to be in, but I think we'll rule you out of order. That table there will rule you out of order. So, ladies and gentlemen, I encourage you to build capacity. Professor Mugai, the other name is hard, but Mohammed, I think is the other name also, was very emphatic on one of the trainings that we had as East African Arbitration Conference. He said the reason why Africa is no longer, was not recognized, number one was competence. World has found not competent in terms of writing our CVs. I think we need to also up our game in terms of how we write, what we've done. There's need to do some little writing exercises in terms of our CVs. But the other aspect also I think that we do, that should be a takeaway today, is the networking events. When we appear for networking events, we don't identify ourselves. By show of hands, how many are engineers here today? Engineers? Fine, we have one. Architects? Architects? Valuers? There you go. Quantity surveyors? Okay. Those are the people who hold our instructions as lawyers for appointment as an arbitrator or even as arbitration counsel. People in leisure and hospitality industry, disputes on not organizing chogam properly in a hotel. Are there any in the leisure and hospitality industry? Okay, fine. But in every space you walk in, there's an agreement being drawn. And these days, people don't prefer court anymore. So every place you go, there's an instruction to pick if you're arbitration counsel or an arbitrator. So I encourage us, especially as women, have your business cards on you. Can you have on the other side of the business card at least something about arbitration, mediation, and adjudication, as opposed to having your picture? So normally when you go for conferences, they turn the card and check what other thing do you do apart from the law staff or the architect staff. So I encourage us to have two first business cards, have something about ADR on the other side of your card. I think I've introduced CLI, I've introduced ICC. Albert, you have something to say about ICC? Later. At the cocktail, yes, I agree with you. Okay. I need to recognize the lawyers in this house, those that have made it off your busy schedule for the afternoon. definitely when I say lawyers, I begin with the judges who've taken off time off their busy schedules. My lords, we thank you very much for making time, especially on such a day. You would be writing away your rulings and judgments and reducing on backlog, but thank you very much for making time for women in arbitration. I will now ask Edith to come. I know we have a few gifts for those who made it here. Edith can advise me if it's now or later or never, but I know it is now. Thank you very much, Edith. Maybe as she comes, I need to tell you something about our ED, Edith. Isn't it? It's right? Correct. So Edith is the founder and executive director of African Women in Arbitration. We are here because Edith decided to start. We're also here because Edith decided to invite us. We're also here because Edith decided to organize this event. With passion, by the way. So when you see her walk up here in red, it is the passion of organizing such an event that is so successful. I must also inform you that she is an arbitrator and a dual qualified advocate. She's an advocate to the courts of Uganda and also the courts of Kenya. So she has at least traversed the East African platform. I think she has done better than many of us. I will encourage you to also try Kenya, but as Barbara told you, practicing in Kenya is next to impossible. I have trekked that journey for the last 6 years trying to become an advocate in Kenya, but the bar course is a limiting. It is very easy, but I need to do the bar also because I've been informed by Attorney General that you must do the bar here just the way how you ask us to do the bar in Uganda. So the issue is now a regional trade issue, free movement of services. I wish Justice Mugenyi was still at the East African Court of Justice. At least we would put our petition there knowing that she will allow free movement of services, of legal services. Otherwise, for now, we are all limited. But thank you, Edith, for traversing a few wins that we've already achieved on the side of African women in arbitration. So under her leadership, she has launched several initiatives, such as the African Women Arbitrators Mentorship Series, which run, then the annual African Women Arbitrator Women's Day event. I think on your cover page of the brochure that you have, that was the Women's Day event that she organized. And also the Herpreneur Mentorship Program. I think women being introduced to entrepreneurship to take the big stride. And then also the African Women Arbitration Symposium, which you have attended today. Edith, you're welcome.
Okay, thank you so much, Kenneth. Let's appreciate Kenneth for being our MC today. I know we ran out of time, but thank you so much for being patient and staying till the end. And of course, we all know it's not the end. Let's network at the cocktail on 8th floor. So we have gifts for our panelists. One of our panelists came all the way. Her bag is here. She's ready to go to the airport. It's sad we won't be able to interact with her at the cocktail, but Aisha has an email address, she has her socials, and she's going to be in the WhatsApp group. I mean, how amazing is that? Let's appreciate Aisha for coming all the way, but also I want to appreciate our panelists, each and every one of them. Mr. Michael Mafabi, Miss Barbara Kiley, Honorable Lady Justice Monica Mugenyi, who is jet lagged, by the way. We spoke yesterday. I know she was in Washington. No, so we appreciate the time you made. No, Maryland, sorry. Our panelists who are online, Madeleine Kimei, thank you so much. Diamana Diawara, thank you so much. Diamana had an engagement today to speak in Cameroon, but she made time for us online. And last but not least, Chizaram Mba, all the way from Nigeria. Thank you so much. our moderators, the most beautiful ladies in the house, Anne and Nanza. Thank you so much for moderating our awesome panelists today. So we just do a gift. We'll just give our panelists gifts. Kenneth?
Okay, fine. Ladies and gentlemen, I think we now go to the gifting time. I will begin with Aisha Abdallah. I know she's about to take off.
Oh my God, I'm so sorry. I missed one important panelist, Miss Olive Saleh. I'm so sorry. Thank you so much. Thank you.
I'll ask Albert to also join at the podium. Otherwise, the ED will be overwhelmed with receiving and handing over. Thank you. So I would prefer that you go in the middle there. Don't mind. Yes. It's okay.
Okay. So we'll start with Miss Aisha Abdallah. Thank you so much. Yeah? Yeah, I think I've been saying thank you ever since you agreed to come. Thank you so much. And clap for Aisha. Okay. Miss Olive Zale. A hand clap, please. Most of you might not know, but I asked Olive to be a panelist at the last minute, yeah? But, oh my God, she was so pleasant. I remember telling Albert, she's so pleasant. Thank you so much for allowing to be a part of this discussion. We appreciate you.
I also appreciate Olive Zale. She nominated me for honorary secretary of the Ghanaian chapter. Good people.
Honorable Lady Justice Monica Mugenyi.
Okay, if you didn't ask a question, kindly clap. Maybe next time you'll ask questions so you don't clap. More clapping. Louder. Louder. And that table will also get a gift. You'll have a drink on me at the cocktail. That table there, yes.
Good. Okay.
A goodbye and safe flight, Madam Aisha. Thank you very much.
Okay. So, Mr. Michael Mafari.
Mike also had to run away, but thank you for sitting in, and is the other good man, friend to the women. Members, can you clap to the friend to the women, the only man who attended? Okay, thank you very much.
And last but not least, I'm so honored to appreciate this very important person. To all of us, but most especially to has been on our advisory committee from inception, Miss Barbara Kile.
Hey, we forgot the clapping, no drinks. Thank you very much, Madam Edie.
Yeah, just before I hand over to Kenneth, I once again want to thank our sponsors, S&L, Jerry Amukamban, Company Advocates, June, kindly stand up. I know you came late. We appreciate you so much. Women Pro Bono Initiative, I don't know if they're here. Please stand up. Thank you so much. Uganda Clays, our MD is here. Thank you so much for taking the time. Amber Advocates and Solicitors. Oh, there's a team here. Thank you so much. ALN Academy, Aisha has just left. LP Advocates, Gimara was not able to make it. Thank you so much. Jojoma Advocates, she just stepped out. And National Union for Lawyers, she's there. Thank you so much.
Thank you very much, Madam Edith. I'll ask members of AMBA to stand up and wave. AMBA advocates, where are you? I work with those people. Yeah, so ladies and gentlemen, thank you very much for the evening. We will thank our sponsors. We'll thank you for waiting till this late hour. Since there was no lunch, drinks are in the evening. So ladies and gentlemen, I invite you to the 8th floor of this same building. Please don't go away. We have a cocktail and eats. All drinks are catered for. I won't mention which drinks. So all drinks are catered for. I'll ask you to also have a networking minute right now. Just meet around, say hi to your lost friends. Since the men are few, I think the men will have a blast. They will go to every table saying hi, hi, hi. And then thereafter will definitely be on the 8th floor. So in 5 minutes from now, kindly don't leave. At least make your appearance on the 8th floor. We agreed that we're going to network. We're going to introduce each other to one another. Businesses in this house, 1 for appointments, 2 for representation. Are we clear on that one? So the rules of engagement are 8th floor, correct? Then we don't leave till 10 p.m. 3 rules, right? 8th floor, we don't leave till 8 p.m., correct? Okay. I'll ask our media people to give us some music to allow us stretch a bit before we go to have our drinks. By the way, there are no seats, so you can begin rehearsing the standing by greeting one another right now. So can we have some afrigo? Oli mujja wa musajja nganze.